All right, good evening. It seems like whenever there's a big action at the court, I reach out to Kevin Schofield of FCC Insight. And tonight, we got word that the ACLU has gone back to federal court, back to Judge Jones, who put the initial temporary restraining order on the SPD around the use of force with tear gas and everything back during the first week of June. The ACLU has now gone back to court. Let me throw the ball over there to you, Kevin, so you can kind of tell everybody what's going on.
Yeah, so if you remember back June 12th, Judge Richard Jones issued a temporary restraining order against police after their crazy use of crowd control devices at a protest. And what he said was, you can't use these except for if there's necessary, reasonable, proportional, and targeted action to protect against a threat of physical harm to themselves or somebody else, or if there's a specific act of violence or property destruction that the police need to stop, right? Other than that, you can't use these against peaceful protesters. And that got issued. And then so we had the events of last Saturday, right? Where, it sure looks like Seattle Police Department was way out of control, and they were indiscriminately using crowd control devices and blast balls and things like that. So what ACLU has come back with now today, they asked the judge to find Seattle Police Department and the city of Seattle in contempt, meaning they violated this temporary restraining order, and because they were using these indiscriminately. They were using them to force peaceful protesters to kind of root in a particular direction or to retreat, and they weren't really giving them time to retreat. And they were tossing things into the middle of crowds really for no reason at all. And they were attacking a bunch of individuals, and they were attacking press, they were attacking legal observers, they were attacking medical personnel who were trying to help people there at the scene. So they're alleging all these things and said, basically these guys are out of control.
Let me ask you a question. And if you know, then fine it. If you don't, you don't. What is there a guideline as in regards to the actual use of say like the flash, I guess you call them blast balls or flash bangs?
Yeah, so there's a couple pieces of this. One, under the consent decree, Seattle Police Department had to go draft a use of force policy and a crowd control policy that say, here are our rules for when we're going to use them and only when we're going to use them. Here's the training that officers have to get before they can use them. And you're not supposed to throw them in the crowd. You're supposed to, you're not in fact supposed to, if I remember correctly, ever throw them like above waist height. It's supposed to be kind of a ground level thing. And so there are all those rules in place for how they're supposed to be used and for how officers are supposed to be trained. And the only ones who are really supposed to be certified to use these things at all are ones who have gone through training for specifically how to deploy them, right? Mm-hmm. And like just, throwing them into the middle of a crowd of peaceful protesters is not part of that policy for how they're supposed to be used.
All right, so they've gone to, the ACLU's gone to court. They're saying that the original order has been that basically the Seattle Police and the mayor, or the Seattle Police and the city of Seattle, are in contempt. And now what are they wanting Judge Jones to do?
So they want the judge to issue a new restraining order that clarifies and sort of gets more specific, kind of like, when we were kids and our mom told us to go do something and we, generalized those rules and found ways around that. And mom comes back and is like really specific. You will go brush your teeth for 3 minutes, and then you will go change in your pajamas, and you will get it. So like they want the judge to be super, super directive on this. So some of the things they said is, you can't use force against medical professionals and media or legal observers, period. You can't use a bunch of these devices to force protesters to root in a particular direction or to retreat. You can't use them unless you believe it's necessary to stop the commission of an act of violence or property destruction. You have to give an audible warning and then give enough opportunity and time. Both time and opportunity means, people retreating have to have a way they can go. So you can't use them against the people in the front of a crowd if everybody's trying to move backwards and they're stuck waiting for the people behind them to move. You can't, they're saying a couple of the kind of bigger points, you can't use non-discriminate chemical weapons, blast balls, or projectiles at all, right? So the only thing they can use, they're asking the judge to say the only thing they can use from this point on are the targeted weapons and not the non-discriminate ones. And then they say that they want the judge to say that a supervisor in SPD must determine that the use of these non-destructive, non-discriminate chemical weapons or projectiles is necessary and it's consistent with this new policy before individual police officers can use them. So supervisor always has to prove it. It won't be within the discretion of a frontline police officer anymore. That's what they're asking for.
Yep. Is there an accountability for like every time that a glass ball or a flash ball or whatever it is used?
They're supposed to be.
Are they supposed to? That's my question is, like, say if there was a box of 50 and they were spread out, are people supposed to count back and be like, well, I threw 4 and this is why I threw those 4, I do 3, or is it just like, man, we just used it? Or if you don't know, then that's fine as well.
My understanding is they're supposed to account for every single one. And I think we're going to see, I'm sure the OPA and the Inspector General are going to be looking at to see like, okay, did you realize you guys really account for all of this when you did this? Or again, were they indiscriminately using this stuff, right? I think that's really going to be a key question. And I think my guess is from just watching the video I watched of last Saturday, I wasn't there in person, I think SPD is going to have a hard time accounting for everything that they did.
All right, so what are next steps in this case? When is it, they filed today? When will Judge Jones hear it? And then once it is heard, you know, what are the steps for the city and the Seattle Police Department?
Yeah, so what happens from here is that the most probable next step is that the city gets to respond to the ACLU's motion, right? They'll write their written response and the judge will decide, he could decide he just wants to rule from there, or he could decide he wants to hold a hearing, in which case he'll schedule a time for them to show up, probably on a Zoom call like this these days, and ask him a bunch of questions, give them a chance to argue their sides of it, and then he'll decide what action, if any, he wants to do. He isn't, I mean, he could simply deny the motion, right? One of the interesting things about this is the way this stuff works is Judge Jones couldn't really do anything on his own about this. He couldn't just order something, you know, order a change to his earlier restraining order. He basically has to be asked by one side or the other to do anything about this, right? So, so that's what ACLU kicked off today. They basically asked him to get involved again, and now he can respond and do stuff, right? So the city and SPD are going to get a chance to respond, and then the judge may hold a hearing. He may just decide, okay, I've seen this, and you know, it may just be that he does that because, you know, what the ACLU submitted with their motion today was like 20 declarations from journalists, from nurses, from legal observers. They sent pointers to social media links to videos from this. I mean, it was pretty devastating what they included with this, just in terms of accounts of all the different harm that SPD caused in doing this. And I think Judge Jones is going to have a really hard time, you know, coming to the conclusion that, oh, there's nothing for me to do here. I'm pretty sure he's going to do something.